Welcome everybody for the very first ELSA webinar. Today here live from the Council of Europe. ELSA, the European Law Student Association, is the largest law student association in the world. Currently, ELSA is represented in 43 countries and has about 50,000 members. ELSA is aiming to contribute to legal education, to foster mutual understanding, and to promote social responsibility among young lawyers and law students. ELSA Webinars is a new project. ELSA International is launching this year, and it aims to connect everyone to the opportunities ELSA offers. It basically offers you to have the opportunity to access any program we have online, from where you are right now in the university or from your living room. At the very same time, today is the 30th of November. It's the last Wednesday in November. It's ELSA Day. For the 5th time in the history of ELSA, the whole network is organizing projects together and is focusing on human rights. So we're very happy to see that we have 150 events taking place today all over the network. And now we are very happy to connect the first ELSA webinar to the ELSA Day. And therefore, tonight's topic is going to be migration law. We are very happy to be in the Council of Europe and be supported by the Council of Europe and have a fantastic panel here sitting with us and going through for the next hour to issues in migration law and human rights related issues. And I would now like to introduce everyone. First of all, Nikolaos Sitaropoulos. He is from the Human Rights Commissioner, and maybe you can introduce yourself a little bit more and say a few words about you.
Thank you, Robert. Thank you very much for this invitation. My name is Nikolaos Sitaropoulos, and I am head of division in the Human Rights Commissioner's Office in the Council of Europe. The Human Rights Commissioner's Office is an independent, non-judicial institution inside the Council of Europe. It has been in place since 1999. We cover all 47 member states of the Council of Europe. We do regular human rights monitoring and reporting on the 47 member states of the Council of Europe. And migration actually is one of the major topics on which the current and the previous commissioners for human rights have worked and were working still.
Okay, thank you very much. Then we have Mr. David Milner with us. He's from the Parliamentary Assembly. And maybe you can also say a few words about what you do and who you are.
Certainly, Robert. Thank you. I'm the Secretary of the Committee on Migration, Refugees and Displaced Persons in the Parliamentary Assembly. The Assembly is composed of delegations from the national parliaments of all 47 Council of Europe member states, and our committee deals with the areas that are covered by its title. I'd like to say something about what this title means, why we use these three terms, because they're quite distinct, certainly in legal terms, quite distinct concepts. When we talk about migrants, we're talking about voluntary international movement. When we talk about refugees, we're talking about forced, involuntary international movement. And when we're talking about displaced persons or internally displaced persons, we're talking about forced internal movements. So these are three quite distinct categories with distinct legal regimes governing their rights. And across this area, the Committee of the Parliamentary Assembly has been very active, especially in the last 18 months as the migration crisis has developed. And we've really been looking at the situation all the way from the borders of Syria through Turkey, the Greek islands, Greece, all the way up the Western Balkans route. We're also now starting to look at integration of refugees and migrants and the situation in the Mediterranean where people are continuing to die. So, yes.
Yeah. Thank you very much. And then furthermore, we're very happy to have Miss Michelle Lafferty with us. She is from the Special Representative on Migration and Refugees. And maybe you can also say a few words about yourself and also maybe why you like what you do and why you're passionate about it.
Thank you. It's a great pleasure for me to be here today. I'm a legal advisor to the Special Representative on Migration and Refugees. The post of Special Representative was created around a year ago now, and our current Special Representative, Thomas Bocek, took up his functions in February. The post was created in response to the growing number of refugees and migrants arriving in Europe. So as you can imagine, it's been a very busy first year. We enjoy very much the dynamicism of the work and hope to build on that in our second year.
Okay, thank you very much. Fantastic. Now I would like to introduce myself. My name is Robert Vierling. I'm the current president of ELSA International. I'm going to be having the honor tonight to be the moderator of this panel. I'm very much looking forward to that. And next to me I have my colleague, Mr. Nigel Micallef. He is the vice president for seminars and conferences. And he's going to show you and going to explain to you how you can basically actively participate in this ELSA webinar, which is one of the aims, to connect everyone from wherever you are to be actively taking part of this. So, Nigel?
Thank you very much, Robert. So, as Robert said, I will be taking care of all the questions that will be coming through to us via Twitter. So for all of those people that are at home today or at an ELSA event with the rest of their friends, feel free to address any questions to any one of our panelists or for the whole panel. And you can do this via Twitter, whereby you write down the tweet and add the hashtag ELSA Day, and also mention at ELSA Info, whereby like that we will be able to see your question and filter through them and address certain questions to the panel. So once again, if you're with your friends or at home, just write a tweet and we'll forward that tweet to our panelists over here.
Okay, thank you very much, Nigel. Yeah, maybe we can start to just give also our audience a general overview. What is the exact role of the Council of Europe when it comes to migration-related matters, and what activities and tasks are there? Maybe, Michelle, you can maybe start.
Well, I would begin again by mentioning the role of the Special Representative on Migration and Refugees. So he has three principal tasks. The first is to gather information on the protection of the fundamental rights of migrants and refugees across Europe. And he does that primarily by going on fact-finding missions to the countries most affected and making proposals for concrete action. He's also mandated with strengthening cooperation of the relevant activities within the Council of Europe. So that means cooperation with my colleagues here present today and with other departments of the Council of Europe that are active in this field. Finally, he's also tasked with enhancing the communication and cooperation with our international partners. So here we're talking about UNHCR, the European Union, the IOM, and so on. We've had a very busy first year, as I said. We've done fact-finding missions to Greece, Turkey, Italy. We've published a number of reports. The Special Representative has engaged in a number of conferences, meetings with international partners, and we're currently working on an EU-wide action plan for refugee and migrant children. I should also say a quick word before we move on about the European Court of Human Rights, a very important institution of the Council of Europe, charged with applying the European Convention on Human Rights, and it's interpreted that convention in a way as to develop rights for the protection of migrants and refugees across Europe.
Okay, thank you. We will come back to that a little bit later. David, can you maybe also elaborate? You mentioned a few things before, but...
I've already described the Assembly, which is this pan-European democratic forum for debate between parliamentarians on the basis of the Council of Europe's values, its values of human rights, democracy and the rule of law. A pluralistic body in terms of nationalities, in terms of political views, but always taking an approach which is based on human rights. We're not the only political forum in the Council of Europe. The Congress of Local and Regional Authorities, for example, is in a sense a sister body, but bringing together representatives from, as the name suggests, local and regional authorities. And they're also active in relation to migration issues, for example, culturally diverse societies, integration of refugees and migrants, local issues concerning access to labour markets.
Okay, thank you very much. And we maybe also have some words, Nikolaos?
Yeah, the Commissioner for Human Rights actually has been active in the migration area since the very start, actually. Since 1999, actually, the first recommendation issued by the Human Rights Commissioner, the first Commissioner was Mr. Robles from Spain. The first recommendation he issued actually concerned the human rights of migrants when they enter and when they are forcibly returned actually from member states of the Council of Europe. That is a very, very important document actually, which I would invite anybody who's interested to look at. This recommendation was issued in 2001. Since then, actually, we have continuously dealt with the issue of migrant rights. Annually, we publish around 10 actually country reports, and the majority actually of the country reports deal with the human rights of migrants, including asylum seekers and refugees. Just a few words actually about some other bodies, institutions inside the Council of Europe which also deal indirectly or directly actually with migrant rights. There is the European Social Committee for Social Rights under the European Social Charter, which covers actually very, very important social and economic rights, including migrants, including also undocumented migrants, and especially vulnerable actually social group, which actually protected in many ways by the European Social Charter. And there are also three other very important institutions in the Council of Europe. The first is the Committee for the Prevention of Torture, which deals actually, they monitor the detention conditions of migrants in all 47 member states of the Council of Europe. Another actually important instrument is the Convention which concerns the protection of victims of trafficking in persons. And there is a special actually experts committee, the so-called GRETA, which monitors the protection of human rights of victims of trafficking in persons in Europe. And finally, there is ECRI, the European Commission Against Racism and Intolerance, a very important actually experts committee which annually also publishes many reports, very important reports on the human rights protection of migrants, including asylum seekers.
Thank you very much. Michelle, maybe we can come back a little bit to the European Court of Human Rights. You mentioned it briefly before. Could you maybe say how the migrants and the refugees are actually protected by the court, and also maybe if there's some new developments lately?
Yeah, of course. I could speak for an hour about the protection that the European Court of Human Rights gives to migrants, so perhaps what I'll do here is a short whistle-stop tour. Yeah. So first of all, we've got protection as regards, for example, the conditions of the detention of migrants, even living conditions as well in the outside world. That's protected under Article 3, which prohibits ill treatment, torture, and degrading treatment. So that's an important guarantee, first of all. There's also the right to have effective access to asylum procedures, and that again is protected by the Convention under its Article 13, which gives people right to an effective remedy. We have protection against expulsion. So if you're a migrant who's in a Council of Europe member state and you're going to be expelled back to your home country, you could rely on Article 2, which is the right to life, or Article 3, which I've mentioned, or Article 8, which is respect for family and private life. All of these rights will enable you to argue against your expulsion if you think that your expulsion is going to interfere with one or other of those rights. All of these different aspects were in play in the case of MSS against Belgium and Greece. In that case, we had an Afghan asylum seeker applicant who had arrived in Europe and Greece but had gone to Belgium. Now the question arose under the Dublin system, which is the EU system for determining which EU member state is responsible for examining an asylum application, whether or not this applicant could be sent back to Greece, which was his country of first entry. Belgium did send the applicant back to Greece, and the applicant then lodged an application with the court claiming that a breach of various of his rights because of the conditions in Greece. Well, the court said that there was a violation of the Convention in respect of both of the member states. First of all, in respect of Belgium, because they had sent the applicant back to Greece to circumstances where his Article 3 rights wouldn't be properly protected because he may not have access to the effective asylum procedures, and because of the conditions of detention in Greece and also the general living conditions that he would be faced with when he returned to Greece. And also found a violation against Belgium on the basis that, against Greece, sorry, on the basis that in Greece itself these things indeed came to pass and these rights of the applicant were violated. We also have the case of Hirsi Jamaa against Italy. Now in that case, the applicants were migrants and asylum seekers on a boat crossing the Mediterranean from Libya. And they were intercepted in the high seas by an Italian vessel, which immediately turned them round and took them back to Libya. So again, the question arose, had they had effective access to asylum procedures? Had they been sent back to a territory where they risked having violations of their Article 3 rights? And the court said, yes, they had. So these are very important guarantees within the Convention system. Under Article 5 of the Convention, there's protection against unlawful or arbitrary detention. And we have a recent Maltese case where the court said that there had been a violation of Article 5 in the case of two alleged minors who had entered Malta and had been detained pending age assessment procedures. And the length of that detention and other conditions of the detention meant that the court said there was a violation of Article 5 in that case. Other protection is under Article 8, which gives certain procedural safeguards for refugees looking for family reunification. We also have Protocol 4, Article 4, which prevents collective expulsion. So what that means is that everybody who's coming into a country has to have an individualised decision before they're expelled to a different place. That was an issue that arose in Claifa against Italy. So in that case, there were a group of Tunisians who came into Italy, and they were all returned back to Tunisia with individual decisions, but the decisions themselves were all in the same terms, and there was no evidence that an individual assessment had actually been taken as to the risk that they faced on return. And in those circumstances, the court said that was a violation. Now, that case has actually been now referred to the Grand Chamber, which is the kind of appeal system for the European Court of Human Rights, and we're waiting on a definitive judgment in the months to come. The other thing I would mention under the Convention is Rule 39 of the Rules of Court, which many people have heard of. That's the provision that allows for interim measures. So if an applicant lodges a case before the court and he's facing imminent expulsion, one can see that the expulsion might thwart the very intention of the case. If the person's sent back to Libya before his case can be examined, then it becomes, he may disappear and be ill-treated before we can do anything about it at the court. So in those circumstances, the applicant can ask for an interim measure, and if that's agreed by the court would then indicate to the member state concerned that they should not return that person until the court proceedings have ended. And failure to comply with an interim measure can itself result in a violation of the Convention.
Okay, thank you very much for this insight. Maybe before we move on to more the financial aspects also for the states, is there maybe a question on the floor, Nigel?
We received one question from a participant that is following the webinar right now, and you spoke earlier in one of your in the second question that Robert asked about the rights of a migrant when it comes to family. So with the right to family reunification, could you elaborate a little bit further on that?
I can maybe say a word or two about one of the cases of the European Court of Human Rights on family reunification. So in the case of Tanda Mazinga against France, we had a Congolese applicant who had obtained refugee status in France. So he was a recognised refugee. And he tried to avail himself of family reunification procedures to bring his family, including his children, over to France. In that case, the proceedings took a very long time. I think they took about 3.5 years in total before the final decision came through. And the court said in that case that that was a breach of his Article 8 right to respect for family life because there were insufficient procedural guarantees to ensure that family reunification had taken place quickly and efficiently.
Okay, thank you very much. David, maybe you can elaborate a little bit on the different economic burdens on different countries who take in the migrants and the refugees, and say a few words about that.
Well, clearly it can be a very considerable responsibility because these are very often people who arrive in a host country completely destitute, forced to leave everything in homes that have been destroyed, travelling with plastic bags and the clothes on their back. When they arrive, they're often traumatised and they need all sorts of material and social and medical services. And this has very clear budgetary consequences. For a country like Germany, which has received, I think, 900,000 refugees, well, fortunately it's a large and wealthy country and it can absorb this cost. Not easily, but it's a cost that can be absorbed. Greece is in a much less comfortable budgetary situation, and the 60-odd thousand refugees who are in Greece are a very considerable strain on the country's resources. Clearly this calls for greater efforts of international solidarity, and this has been a very strong emphasis of the Assembly's work on what's often referred to as the migration crisis. But more has to be done for effective responsibility sharing, and that solidarity has to be shown not only in political terms but also in material terms. So it's certainly not something which can be minimised. It's an important part of the political equation.
Okay, thank you very much. Maybe Nikolaos, you can just pick up on there and go a little bit. Is there a legal basis for like an international support of the countries who are facing these problems at the moment?
Yes, of course. Actually, the principle of international cooperation and solidarity is a principle established in international law, both in soft international law and hard international law. If one goes back a bit 50 years ago and looks at the preamble actually of the UN Refugee Convention, inside the preamble of the Refugee Convention, there is a clear, actually, declaration of international responsibility of all states concerned towards refugee flows. Under the UN Refugee Convention, all members bound by the UN Refugee Convention are actually obliged through the preamble of the UN Refugee Convention to show solidarity to each other and share their responsibilities towards refugees. This actually principle was very recently pronounced also in the so-called New York Declaration by the heads of state and government. It was convened last September actually in New York. Inside this declaration there's a clear paragraph actually saying that the states which were in New York, the heads of government and state, undertook actually to share responsibility towards large flows of refugees and migrants. Now, how this is translated into action is another issue, but at least it is clear that this principle of shared responsibility and international solidarity has been established in international law. As far as the European Union is concerned, in particular, there is a very, very clear provision inside the Treaty on the Function of the European Union. This is Article 80. According to Article 80, the policies, the immigration and asylum policies of the European Union actually are to be governed by the principle of solidarity and fair sharing of responsibility, including its financial implications. So the EU law is very, very clear as far as the sharing of financial implications are concerned in the area of immigration and asylum. So at least inside the European Union, one can say that there is a very, very clear and hard law by which EU member states are bound to share their responsibilities and burdens which may incur in the context of migration flows, especially in the context of large migration flows.
Okay, thank you very much. And just very, very briefly, because we have to move on, is there any protection, any possibility for any socio-economic claim from an individual migrant? Is there any legal basis for that?
Well, the social and economic rights of migrants, at least in the 47 member states of the Council of Europe, are covered, as I said earlier, by the European Social Charter. The European Social Charter actually has enshrined a number of very important economic and social rights, like the right to social care, the right to employment, the right to liberty from social exclusion and extreme poverty, which are very, very important issues concerning all migrants, actually, both regular and irregular migrants. Now, with regard to the status of migrants and their social rights, under the European Social Charter, actually, migrants are entitled to these rights under the European Social Charter so long as they come from other member states of the Council of Europe, which are contracting parties to the European Social Charter, and at the same time, they are to be lawfully present, actually, in European states, Council of Europe member states. But there is an exception. There's a very important exception, actually. Since 2004, the European Social Rights Committee has actually developed a very important case law under which even undocumented migrants, irregular migrants, are actually entitled to certain minimum social rights, like the right to emergency medical care and the right actually to shelter. The European Social Rights Committee actually started with some important case law in 2004, which covered children, migrant children, and their under irregular actually status, and their right to emergency medical care and their right to shelter. And recently, actually, there was a very important judgment against the Netherlands, which concerned actually irregular migrants and their right to emergency shelter. So no one should live on the streets under the European Social Charter. States are bound to provide this kind of protection, minimum protection.
Okay, thank you very much also for giving us an overview on this. I would like to address our audience just in between. If you would like to join, once again, just go on Twitter and drop a post, and we can ask the question here right to the panel. Now we move on, and maybe David, you can talk a little bit about the failures and the cause for the failures of the Dublin system, and elaborate a little bit on that part.
Well, this is another area that the Parliamentary Assembly has looked at quite closely in a report last year called After Dublin, the urgent need for a real European asylum system. And the Assembly was very critical, really, of the Dublin system. It used the expression, the Dublin system is inherently dysfunctional. And it said this for a variety of reasons. One of these is because it's not designed as a burden-sharing mechanism, and its very operation is bound to result in inequity. And this is exacerbated by the fact that the kind of mixed migratory flows and their geographical focus today is not at all the same as was the case in 1990 when the Dublin regulation first came into effect. There's no compensatory mechanism, so there's no way of balancing this inequity. And we also saw that in operation, the Dublin system was giving rise to a whole catalogue of violations of asylum seekers' rights, including inhuman and degrading treatment, arbitrary detention, lack of respect for private and family life, lack of access to effective remedies, even collective expulsions. People who are in this system face lengthy periods of uncertainty and precarity. And so really we thought that there had to be a replacement for the Dublin system because the Assembly saw it as really dysfunctional.
Okay, and just maybe to pick up on that, which steps would have to be been taken to have a more fair, more sustainable system for the European asylum seekers?
Well, as far as the Dublin system is concerned, the Assembly had two really quite specific proposals, which might seem very specific, but in fact would have really wide-ranging consequences for the functioning of the system and potentially could address, in the Assembly's eyes, a lot of the problems that were arising in its application. So one of these would be to remove the criterion of irregular border crossing, which is something which says if an asylum seeker enters the territory of the EU, then whichever border they first cross, for example, Italy or Greece, that is the country that should be dealing with their claim. Now, there are exceptions to this, but in very many cases, people are returned to Italy or Greece, and yet these are the countries with the most people. And very often people don't want to be there, often for family reasons. They have family in another country and they find themselves in already overburdened countries, separated from their families. So the Assembly says, get rid of that. It also said, introduce a concept of manifestly unfounded claim, so that people are not left in a period of limbo, so that applications which are clearly ill-founded can be dealt with more quickly. But in this report, because as I said, its title was about towards a real common asylum system, there were proposals about the wider common European asylum system. For example, that there be stronger centralised supervision of national asylum procedures. One of the problems in Greece, for example, in this MSS case, was that the Greek asylum procedure was not considered reliable enough a remedy against refoulement, against unlawful return to countries of origin or third countries. So our proposal would have been have central supervision of the Greek asylum system. Have mutual recognition of positive refugee status decisions so that refugees can more freely be transferred from one country to another, and or allow them greater freedom of movement once their status has been recognised. And then there's a lot can be done in more practical terms to make sure that in many cases, already existing EU mechanisms for supporting and balancing difficulties operate more effectively. Because a lot is being done by the EU, but its impact is not yet sufficient to remedy all of the problems that the member states are facing. So for us, these are human rights issues, because they affect the situation of the migrants. It's not the Council of Europe putting itself above the European Union. It's the Council of Europe as the source, for example, of the European Convention on Human Rights, making sure that when member states of the European Union are applying whatever source of law, they do that compatibly with their obligations under the European Convention. So this is our approach.
So is that basically like, can you conclude from that that you say that the Dublin system is not compatible with international human rights?
I think that would be going too far. As I said, For the Assembly, there were some inherent flaws in the structure of the system. But whether these are, let's say, human rights flaws or policy flaws, in the sense that they predictably create imbalances in responsibility, in the burden of responsibility, and that these especially, and as is shown through the case law of the court, manifest themselves when the Dublin system is put into operation. And the imbalances are not remedied and even exacerbated. And we have the judgments of the court, we have a judgment of the Court of Justice of the European Union in broadly similar terms, and we also have human rights-based judgments of national courts, which have said that return to countries other than, there's an Italian case in Strasbourg, there's the MSS case, but for example, returns to Hungary under the Dublin system are not compatible with national obligations under the European Convention on Human Rights.
Okay.
But these are flaws of operation, I would say, rather than fundamental human rights incompatibilities of the Dublin system per se.
Would you agree to what has been said?
Absolutely, I agree. The logic, actually, the logic of the regulation, the so-called Dublin regulation, and its ancestor, because before the Dublin regulation, there used to be the so-called Dublin Convention in 1990, actually. So the logic, actually, of the Dublin regulation and the Dublin Convention has been actually to create a fair system of responsibility sharing towards asylum seekers in Europe. If one looks actually at the preamble of the regulation, the Dublin regulation, in its latest version, one can see actually that aim of the Dublin regulation is to create a system by which responsibility sharing would occur actually on the basis of objective and fair criteria. This is a very reasonable, actually, aim, and I mean, it is really there's no flaw actually with this aim. The problem is that the whole system has been based in practice, as David just said, on the principle of first country of entry, and in practice, the first countries of entry for asylum seekers in Europe, basically nowadays, is either Greece or Italy. The problem is that at the same time, the Dublin regulation has established other very important criteria, like criteria which concern minor asylum seekers, and under this criterion, actually, minor asylum seekers should immediately be joining their family members in other European member states where they are. And it appears actually that this criterion actually is not actually applied in practice in Europe nowadays. There's also two other very important criteria under the Dublin regulation, under which actually an asylum seeker should join family members in other member states of the European Union if those family members have requested asylum and their asylum application is pending, or if they have family members in other European Union member states where members actually of an asylum seeker's family have been granted asylum. And these, unfortunately, we can see actually that in practice these criteria are not really applied. And there is a huge emphasis on the first criterion mentioned earlier, on the first country of entry, which actually imposes de facto a very, very unfair burden and huge responsibilities on the entry countries of the European Union. And this is, in practice, as I said, Greece and Italy. So the fundamental flaw actually is the overuse, or abuse, I would say, of the criterion of the first country of entry inside the Dublin system. This is actually a criterion which should be fundamentally reviewed by the member states of the European Union.
Okay.
Robert, if I could just add a couple
of course,
of words about the practical side of things. Obviously, the special representative has been to Greece and Italy, and also actually to Turkey, where we see a lot of land arrivals. Greece and Italy are concerned with sea arrivals. In each of these countries in 2016, Greece and Italy, we've seen about 170,000 migrants and refugees arrive by sea. Now, all of these migrants and refugees, if they leave, they're theoretically at least supposed to be returned to these countries, while on the other hand, the EU set up this relocation system in order to try and address the fact that there are so many people arriving. but relocation offers aren't coming in as quickly as people would like. So that means that there's no scope for these people to leave the countries, but they're all getting brought back as well. And what we saw then on the ground was exactly this problem that both Nikolaos and David mentioned about excessive numbers. That creates problems as regards the conditions in which they're housed, accommodated. The other issue is exactly as Nikolaos just said about children under the Dublin system and the right to family reunification. Because what we saw in various different places, we were also in Calais in September, serious problems obviously there with the informal camp. What we saw was that the procedure for reuniting unaccompanied minors with their families in other EU member states didn't seem to be working effectively as it should, and that steps need to be taken to tackle that.
Okay, thank you very much, and it's always fine to jump in, of course, as well. I think Nigel has received them.
We have received some questions, in fact, and also I'd like to address the audience that are speaking to us right now through Twitter. Please always rephrase your questions in a European perspective so that we can tackle them with our experts today that are from the Council of Europe. So the first question that we received states the following: what can local communities do to improve the situation for refugees within their country? So to any one of you from the panel.
The local communities. Or I can say a few words about the local communities. Actually, we say in the Council of Europe and many other human rights organizations that human rights protection starts at home. And by this, we mean that the fundamental, actually, human rights protection is very much based on the way in which local communities or regional communities actually can provide effective protection of human rights to migrants and refugees who live actually in their areas concerned. Fundamental actually aspect of human rights protection is, as far as migrants are concerned, is integration actually. Their integration into the host in the host communities. And by integration, we mean full acceptance of those newcomers in the host societies, the acceptance of migrant children in schools, their full enjoyment of the right to education, which is a prerequisite actually for migrant children all over the world. The migrants' right to enter the labor market, actually the right to participate in the political processes in the host societies, by the way, I should mention actually very briefly that the Council of Europe actually has a very important convention which provides for the right of migrants to participate in local and regional elections. This is a very important convention which has been ratified to date by very few actually member states of the Council of Europe, but it's of seminal importance because if the newcomers, the migrants, do not really participate in the political processes in their host societies, they will never be fully accepted and their voices will never be heard by the political elites. And this is actually what we see nowadays. There's a lot of, there's a rise, as you know, of hate crime, hate speech all over Europe. And that one of the reasons for which actually these very, very sad phenomena occur is because migrants have not really managed to be fully participating members in the political bodies, the existing political bodies, either at local, regional, or even national level.
Okay, and does anyone else maybe want to?
From a practical perspective, I could probably say a few words as well, because when we visited these different countries, we've been to lots of different places and seen differences in practice between countries, but also within countries. And that comes down exactly to the approach taken by the local authorities to migration issues. So I would say that in many of the places we visited, the mayor can have a really central role, because the mayor can determine the nature of the debate within the community on migrants and refugees. Where you have a very open mayor, a very tolerant mayor who promotes integration, as Nikolaos mentioned, then you have a much more successful experience with migrants and refugees compared to places where maybe you have a mayor from a more right-wing party who's less open to seeing refugees and migrants in the community. We've seen that having a massive impact on education when we went to the northern France camps. So in Calais, for example, none of the children there were in the local schools. Whereas in the camp of Grande Sainte, which is about 40 minutes away and it's in a different local authority area, the local authorities had been involved in starting this project whereby children in that camp spent the afternoons in the local schools. And that was a very, very positive development that we saw in that area. I could also mention the approach in Italy. Italy, one of the things they're trying to do to tackle the very high numbers that they're now receiving is to roll out a countrywide programme whereby smaller centres of maybe sort of 10 to 15 people are opened up in local communities, and these smaller centres can then be tailored to provide the services that asylum seekers and refugees need to properly integrate. Unfortunately, for the time being, there's not been a massive take-up. I think there are about 8,000 local authorities in Italy and only 1,000 participate in this scheme. But those who do participate have recognised the benefits because there's funding available to try and help migrants and refugees, European funding and funding from central government. It can generate jobs in the local community. In smaller communities, the influx of children can keep local schools open. There's all sorts of possibilities for business opportunities when migrants and refugees come into the area. So I think there's lots that local communities can do if they open their minds to try and embrace these possibilities. And there is a programme in the Council of Europe, the Intercultural Cities, which some people may have heard of, which is basically a network of cities trying to promote intercultural practices, and cities can apply to become a part of that network and then participate in sharing of best practices and so on to try and promote the inclusion of refugees and migrants in their societies.
Okay. Nigel, I think you have
we have one more question for this set of round of questions. So the second question is the following. How is freedom of movement dealt with when it comes to migrants? So to anyone of the panel that can answer this question.
I think it depends whether you mean freedom of movement within a country or freedom of movement between countries. Obviously the latter, freedom of movement between countries, is migration. It is the forced displacement of refugees. Now, within a country, normally, all individuals should be free to circulate freely. We see in some countries that's not the case. If you're an asylum seeker who has landed on one of the Aegean islands, one of the Greek islands in the Aegean, you can't leave the island. You're free to circulate within the island, but you can't go to the mainland. This is, in a sense, one of the consequences, if not one of the provisions, of the EU-Turkey agreement of March this year. So there is, in certain circumstances, this restriction on freedom of movement within the host country of a migrant or an asylum seeker. Then the other question is freedom of movement between countries. Well, there, on a factual level, the situation has changed a lot since the summer of 2015. You may remember in, I think it was August, there was the explosion of transit migration along the Western Balkans route. The great pressure at the border between Greece and the former Yugoslav Republic of Macedonia, the sudden opening of the border, and the dramatic flows, really enormous flows of people from the Greek islands to the Greek mainland, then through the borders to the north, all the way to Austria. Now, this was a completely unprecedented approach to freedom of movement, this absolute liberty to cross borders, because we followed the route while this phenomenon was taking place. And there was effectively no obstacle to the migrants, not while we were there. The obstacles started to be introduced at the end of 2015, the beginning of 2016. There were daily quotas and things like that. But in the autumn of 2015, it was free movement all the way from Greece to Austria, in effect. And then a third aspect I would mention, which is something I talked about when we were discussing Dublin, whether a refugee who has been recognised in one state is then free to move to, I guess this would apply, another EU member state. And that's a different situation. I think free to move, yes, but free to relocate in the sense of take up residence in another state. This can be done, but subject to quite limiting conditions. So you couldn't say there is freedom of movement, at least not for a certain period of time, for somebody who's recognised as a refugee in one EU member state. So, like I say, it's a question you have to look at the context. Freedom of movement between where, for whom.
Thank you very much.
There's another aspect, if I may, there's another aspect actually directly related to the freedom of movement. This is the overuse actually by European states of migrant detention. I can refer back actually to the 2001 recommendation made by the Council of Europe Human Rights Commissioner. Under this recommendation, actually, detention of migrants should never be used in principle. And because the irregular entry or irregular presence actually of a migrant inside the country is not really a criminal offense, or it should not be a criminal offense. What we see actually nowadays is the overuse or abuse actually of detention of migrants by the vast majority, I would say maybe all of European member states. It is a very, very unfortunate phenomenon. Because in the majority of the cases, actually, migrants are detained, even asylum seekers actually are detained in really substandard conditions. The situation in the hotspots in Greece, for example, is probably the most evident case of very, very substandard conditions in which asylum seekers and migrants in general actually are detained at the moment. These are very, very important issues. They raise fundamental human rights questions about migrants' human dignity and the way in which they are treated by the majority of the European states. The Commissioner actually has systematically promoted the principle of non-detention of migrants, and he promotes also the use of alternatives to detention of migrants. Many actually European states have alternatives to detention enshrined inside their legislation, but there are many states actually who do not really apply alternatives to detention, and this is actually an issue which requires further reflection and examination.
Okay.
If I could just add on that point.
Of course. Yeah.
The Council of Europe is currently working on both of these issues at an intergovernmental level, so a standard setting level. There are groups of experts working on the conditions of administrative detention of migrants, and another one on alternatives to detention for migrants. Now, both are at a fairly early stage in their work, but the idea is, if everything goes well, that this work will lead to presumably recommendations, so soft law instruments, non-binding instruments of the Committee of Ministers on detention of migrants, and to encourage alternatives to detention.
Okay, thank you very much. I think we will now move on to go a little bit more into the international human rights matters. And there's always is there a balance? It's a question between the sovereignty of the states and the international human rights when there is mass migration coming into their countries. Maybe, Michelle, you can...
Well, of course, states remain sovereign to set their own migration policies and asylum rules, but they're subject to international law, and that includes international human rights law, and it includes any treaties and conventions that they've signed up to. In the context of the Council of Europe, that means the European Convention on Human Rights. So when we look at the activities within the Council of Europe legal field, if I talk about the Special Representative, that's an example of a very cooperative process. So the Special Representative on Migration and Refugees, he's not a monitoring body. He goes to the states affected, he tries to identify the problems, and then when he writes his report and identifies those problems, he also proposes some action that the Council of Europe as an organisation can take to support the member state in question. And the next step is to engage with the authorities of the state to try and discuss how our office, the Office of the Special Representative, in coordination with the other departments of the Council of Europe, can provide this assistance concretely to the state. So for me, that's a very nice example of a process that respects state sovereignty to a large extent. When we come to more binding standards, there we're in the domain of the European Court of Human Rights. Obviously, the judgments of the court are binding on the countries, on the parties in the case before it, and the execution of those judgments is supervised at intergovernmental level. When we talk about the fundamental rights, the core rights, Article 2, the right to life, Article 3, prohibition on torture, there the standards are really quite strict. You can't expel a person to a country where he's going to face a risk of ill treatment, and you can't expel even a terrorist. There's no exception to that rule. It's an absolute rule. So that, in many ways, can be perceived to be quite an encroachment on state sovereignty. But when we move into the domain of the qualified rights, like Article 8, the right to respect for private and family life, it's quite different. There's a large margin of discretion that's given to member states to determine who's allowed to come in and who's allowed to stay in. And it's only in specific circumstances that the expulsion of a person would be in breach of Article 8, and it's much more limited circumstances. So there is a balance being struck by the court, and you can see the different spectrum when it comes to the difference in importance, let's say, of the rights concerned.
Okay. Does anyone of you want to follow up?
A few words more actually about international migration law and international human rights law. Actually, international migration law is a multi-layered body of law. It consists of various forms of international law. It's human rights law, but at the same time, it is also directly influenced by domestic constitutional law, for example, or domestic administrative laws. So there are many layers actually of laws which actually provide various levels of protection to migrants. Now, as far as Europe is concerned, I would say that the highest, on a pan-European level, the highest level of protection right now is provided by the European Court of Human Rights as far as migrants are concerned. And this is because the judgments of the European Court of Human Rights are binding. This is in theory. In practice, the problem is that there is a serious issue of execution of a number of judgments rendered by the European Court of Human Rights, including judgments concerning migrant rights. And I would give a very recent example. Recently, last July, the European Court of Human Rights issued a number of judgments against France concerning actually the detention of migrant children in substandard conditions in France. These are judgments actually which were delivered by the European Court of Human Rights following a very important, very similar judgment against France, the case of Popov versus France. That was a judgment actually which was rendered in 2012 and concerned exactly the same issue, the unlawful detention of migrant children in France. And we see that 4 years after that judgment, the Popov judgment in 2012, we see 5 new judgments again against France concerning exactly the same issue, which shows that this particular member state of the Council of Europe did not manage to fully execute the first judgment of the court in the case of Popov. And I can mention many other actually cases which raise similar problems. For example, the case of MSS against Greece has been, the execution of the judgment against Greece has been pending before the Committee of Ministers of the Council of Europe since 2011. Now we're in 2016, almost 2017, and this case is still pending for execution before the Committee of Ministers. This is another issue. It is the very slow actually execution of judgments by a number of member states of the Council of Europe. The execution of judgments is a very serious issue. Actually, recently the Commission of Human Rights issued a special human rights comment, which actually raises the issue, and the Commissioner proposes the amelioration actually of the supervision system, the supervision in the Council of Europe, the supervision concerning the execution of judgments by the member states. But at the same time, member states should do more actually at national level in order to accelerate the execution and especially the effective execution of the judgments of the European Court of Human Rights, including those concerning migrant rights.
Okay, thank you very much. David, you?
Well, the Assembly is looking at this tension between state sovereignty and human rights, which, well, I think tension is probably the wrong word, because state sovereignty is reinforced by respect for international legal obligations. State sovereignty is strengthened by a framework of mutual respect of common obligations, and states can't operate unless they're able to rely on the other states fulfilling, for example, treaty obligations. So to say there's a tension, I think, is a slight misconception. But certainly there is, despite the often clarity of the law, especially the international law, the problem comes when it's a matter of applying the principles in detailed domestic legal provisions and administrative practice. And we see the complications of this in the political debates in the Parliamentary Assembly, where on particular issues, quite reasonable and often legally sound opinions can be expressed that are really quite opposed. So the problem is in the application of this international law and finding a way of reassuring those who consider, let's say, state sovereignty issues like border control and public safety and national security, reconciling their priorities with those who prioritise, perhaps to a greater extent, protection of the rights of migrants and respect of the procedural rights towards asylum seekers, access to territory, these sort of things. There are ways, but very quickly the issues become political rather than just legal.
Okay, thank you very much. Before we move on to the last two questions we want to discuss here, I would kindly remind our audience to, if you want to have some questions, to go on Twitter now and to drop them down, so we can ask our panel to answer them. So, Michelle, one of the rights which for the refugees which ensures that they are protected is the non-refoulement principle. Could you maybe quickly explain what this is to our audience, and then also, if it not applies, how maybe other laws can protect them?
Absolutely. So non-refoulement is a core principle of international refugee law, and it prevents a refugee from being sent to a territory where his life or freedom would be threatened. And that's the basic principle. There's additional protection provided by international human rights law, because whereas the Refugee Convention protects refugees, human rights law protects everybody. So under, for our purposes, Article 3 of the European Convention on Human Rights, you're prohibited from sending someone back to a place where they would be at risk of treatment in breach of Article 3. So that's torture or inhuman and degrading treatment. All of these people obviously benefit from quite a strong protection under international human rights and refugee law. When we talk about subsidiary protection, these are people who don't maybe meet the qualification to be a refugee, but nonetheless have some kind of fear of risk of serious harm if they're returned to their country of origin or to the place where they're supposed to be sent back. So they benefit from what we call a subsidiary form of international protection as well. But it's the same kind of principle, that they can't go home. On the other hand, we have economic migrants. Their situation is very different. They're looking for a better life, better employment opportunities. There's no question that there's a risk of harm when they go home. They can go home anytime they like. They just don't really want to, you know, for reasons, for economic reasons. These people can't benefit from the principle of non-refoulement because there is no risk when they go back, so there's no protection to catch there. However, Article 8 of the Convention, as I mentioned earlier, protects the right to respect for private and family life. So where you've got economic migrants who've entered a member state and have established some kind of private or family life there, they may be able to rely on the Convention to prevent their return. The right is not absolute, as I said earlier, so what the court looks at is whether or not there is a legal basis, whether it's in accordance with law, the expulsion, whether it pursues a legitimate aim, and whether it's proportionate. And the court has this general list of factors that it takes into consideration when trying to determine whether an expulsion of an economic migrant is proportionate. So things like the length of stay in the country, the strength of any family ties, the best interests of any children concerned. And quite often the cases that we see involve economic migrants who've come over and committed criminal offences. And so in those circumstances, the court will take a look at the seriousness of the criminal offence that's been committed. And only by balancing all of those different factors together would it decide not to expel someone to a country who's an economic migrant.
Okay, thank you very much. To come to one of the last questions, unless someone from the audience maybe has something. Human dignity is like the minimum standards for when it comes to migrants and refugees when we look at the whole situation. Is there any mechanisms to prevent inhuman and degrading treatment at the moment? Maybe Nikolaos can...
Well, there are two major mechanisms in the Council of Europe, actually, which prevent inhuman and degrading treatment, or they try to prevent inhuman and degrading treatment by member states. The first one is, of course, the European Court of Human Rights, through the application of Article 3, which prohibits, as you know, torture and other forms of ill treatment or degraded treatment. And the second actually major mechanism in the Council of Europe is the Committee for the Prevention of Torture, which is one of the major human rights monitoring mechanisms in the Council of Europe. They carry out regular annually visits to all member states of the Council of Europe. They are in a constant dialogue with the member states. They visit prisons, detention centers, as well as persons with disabilities which are deprived of their freedom and they are kept in psychiatric asylums, for example, psychiatric institutions. It's a very, very important body. It has actually created a very important, very rich expertise, sort of case law, I would say. So in their annual reports, they also publish usually some very, very useful guidelines to member states with regard to the conditions of detention and the standards under which persons should be deprived of their liberty. One of the fundamental, actually, freedoms of all individuals.
David?
I think if you're saying that dignity is something to be assessed by reference to inhuman and degrading treatment, you're setting the bar too high. Dignity is a much more profound and multifaceted concept. I think really when you're talking about dignity, you should be talking about everything to do with the situation of the individual and whether this person is able to, let's say, to feel and express their humanity. We can look at it as lawyers through the optic of legal protections of international law, the sort of provisions of the European Convention on Human Rights that Nikos has mentioned. But we also need to look at, for example, reception conditions, accommodation, access to education, access to healthcare, socialization, engagement with society. In the longer term, broader principles of integration, access to labour market. The Council of Europe is, as we discussed at the beginning, has a whole wide range of activities which try and encourage states and national authorities to take greater action in these areas, because they all come together, the law, the practice, the politics. They should all be seeking a common goal, which, as you say, is to ensure the dignity, the basic dignity of the individual.
Okay, thank you very much. Nigel, I think you
we have a couple of questions, but I'll have to choose two, I guess, because we're running out of time, unfortunately. So we received a question from Ukraine asking, how can the Council of Europe evaluate the situation with internally displaced persons in Ukraine as a result of the occupation crisis?
The Commissioner actually has been monitoring the situation in Ukraine for some time now, and I think we can all agree that this is one of the major human rights problems which requires particular attention by the international community and the states concerned. I don't have specific data in front of me at the moment, but what I can say as far as the Commissioner for Human Rights is concerned, at least, this is certainly one of the major issues which we monitor, and we try to intervene as much as possible in order to ameliorate actually the conditions of living of those persons who have been actually affected by the war in that region in Europe.
There are also a number of cases before the European Court of Human Rights lodged by people affected by what's happening in Ukraine. There's also interstate cases. We haven't really said anything about that, but that's a state brought by a state against another state. So we have two principal interstate cases brought by Ukraine against Russia. And in the context of those cases, obviously, the court will be looking into what's going on in Ukraine in determining how it's going to dispose of those cases. And in doing that, it often relies on, for example, reports of international organisations, NGOs, IGOs, and other material that's presented to it. So there are mechanisms for keeping an eye on what's going on.
Okay, thank you very much. I think we have to move on to the next question, because
we received another question. This participant asked the following question: people that are leaving safely from conflict-free countries that are seeking better social benefits, do they still count as refugees, or are they economic migrants?
These people would fall into the economic migrant category. You're only a refugee if you meet the strict definition in the Refugee Convention, and you can only benefit from subsidiary protection, a form of international protection, if you can show some risk of harm in the country to which you have to be returned.
Put in those terms, clearly, you're describing a non-refugee and then asking if that person is a refugee. Well, obviously not.
Okay.
We have a lot of questions coming in right now, but I'll ask one last question. This is a follow-up question to the question that I asked before earlier in the webinar. When we tackle the issues with regards to local authorities, how can they find help? However, the question now is, what are the main problems that local authorities are facing to date?
In Europe, you mean, and with regard to the integration of migrants and the human rights protection? Well, I would say that the majority actually of the local and regional authorities have not received to date the appropriate support by the central authorities. That's one of the major issues, especially in states, in member states of the Council of Europe, where there is no real federal system of governance. On many occasions, actually, local authorities are very much dependent on the central authorities of the states concerned. I think that the central authorities in the majority of the member states should actually provide for more support to local and regional authorities in order to promote integration of migrants and refugees in the areas. I think the local and regional authorities also need a much more human rights awareness and education. On many occasions, I have the impression that the staff members working for migrant integration or refugees do not actually have the appropriate background expertise in order to deal effectively with those people. But as I said earlier, I think the primary responsibility, I think in the majority of the member states, lies with central authorities. They should provide more support, more financial and human resources actually support to the local authorities in order to promote effectively the human rights of migrants and refugees who are actually residing in their areas.
Yeah, I'd fully agree. I'll give an example. The Migration Committee of the Assembly sent an ad hoc subcommittee to COS in the autumn of 2015. And what we saw there was the local authorities were doing almost nothing, with the explanation that they simply didn't have the resources. The local economy had been very badly hit by the reduction in tourist numbers, and the central government wasn't providing them with anything so that they could provide for the asylum seekers, who were arriving in huge numbers then. But the local community was making an enormous effort. I think everybody around the world heard of the baker of Kos, who we met, who every morning drove to the harbour with a van full of baked goods and distributed these free to the people who were stuck in tents and wrapped in blankets along the shoreline of Kos. And there were any number of local NGOs and volunteers, businessmen, who were making a really impressive, very impressive effort to help these people. So local communities are really in the front line, I think. Even before it's an international political issue, this refugee crisis, migration crisis, it's a local issue, because these are concrete people in specific situations surrounded by communities. And this is where the problem has to be addressed.
Okay, we reached the end of this panel discussion. I would like to thank the three of you. It has been very nice and to have you here, and also that you were able to answer the questions of our audience today. It really shows that this is a program which works and which is interactive. So thank you very much for your contribution tonight. It was our pleasure to have you here. And to maybe conclude what has been said today, I think it is very important for everyone watching and for ELSA and in the Council of Europe to work on these issues and to educate already the students and the future generations of people coming in, and in general also the broader audience to have an informed discussion about these matters and not just follow whatever is presented, but actually look also under the legal aspects of this matter. So therefore, thank you very much that you shared your knowledge with us. One last thing I would like to say, it's a big thank you to the Council of Europe for providing us with the opportunity to come here. We are cooperating now since several years, and we both, ELSA and the Council of Europe, are working on raising the awareness for human rights. And it was a pleasure to be here tonight. And also a big thank to my colleague, Mr. Nigel Micallef, who push this project forward to have these webinars. And yeah, I can only say to everyone watching, stay tuned for more to come, and thank you very much.